Now I find you guilty based upon the revocation of your probation. I find you guilty beyond a reasonable doubt of this state jail felony. And you were hereby,
No, it's not my case. She just told me what the stolen, because I asked her if it was a felony or if it was a shoplifting with private.
No, you have my trust you know I was coming off.
Well, he doesn't there, so then I.
did she need to swear in on anything?
All right. So
No.
Yeah, I don't need her.
Right.
24 CR 530 is called the state of Texas versus Michael. Is it Ravine or Revenue?
Yes, sir.
Ravine Peterson. That's you.
Yes, sir.
And it's Michael, that's the way you pronounce it?
Yes, sir.
Oh, not Michelle, but Michael. Okay.
Yes.
It's spelled like the Christian name Michael.
I think they want up more.
Yeah.
They want
They could change the name, to Michelle or something, but apparently this is what they thought was very, very unique. Nonetheless, you're here with Mr. Kindler, your attorney, and the state's attorney. You have been placed on probation for 5 years, deferred or unadjudicated probation. And that was back in June, about a year ago now. And what we have is
We're going to proceed on count one.
a first amended motion to revoke probation. That what happened to this failure identified thing?
It's been filed, but I looked at it and it's not something that I'm really concerned about.
All right, but we got some other violations, failing to report, failing to provide verification of performing community service hours, failing to provide verification of completing the anger management program, which is important, especially with this charge. You need to know how to control your emotions when you're in a difficult situation. Everybody does. And then failing to pay court assessed fees. And then finally, there's a new case of failing to identify. Is it fugitive? Is that word?
I don't know.
That's what it's supposed to be, right? Fugitive?
I would make it a class A issue for a fugitive.
Is this failed to identify, is it
Fugitive from justice.
fugitive intent, give false info?
Yeah, it's fugitive from justice with intent to give false info.
Well,
That makes
the way it came out, the way it got typed, it's misspelled.
Oh,
That makes it.
we're not proceeding on that, Judge. We're abandoning that, so you can scratch it out and not worry about it.
Don't worry about it.
We're proceeding on count one, the failure to report.
Still needs to be spelled.
No, it doesn't. It
It
does
says
not need
he's
to be
abandoning.
spelled.
Official record.
I abandoned the spelling.
It's fugitive. It's a
Me too.
FEGITIVE.
We're gonna have a hearing on this.
But that's the way some of the prosecutors pronounce words.
So.
There's is a southern thing. Fugitive.
Well,
I have to correct the hearing on it.
All right, we're going to proceed in summary, right?
yes, sir.
All right, ma'am, raise your right hand. You solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Lower your hand. In summary, and we're waiving a formal reading of this first amended motion to revoke unadjudicated probation filed April 6th, 2026 in this case.
My former.
In summary, this alleges that on June 18th of last year, 2025, in this court, you were placed on 5 years deferred or unadjudicated probation for the lesser included attempted harassment of a public servant. I presume there was harassment of a public servant and you pleaded guilty to the state jail felony of attempted harassment. Is that correct?
Yes.
And that was a state jail felony. And allegation 1 states that you failed to report to the Jefferson County Probation Office on or about October 1st, October 21st, November 20th, December 18th, 2025. And those were all violations of condition 4 of your probation order. And that probation order, I'm going to get to it, states that you shall report as directed by your probation officer and obey all rules and regulations of the Jefferson County Probation Office. So did you fail to report as required on those dates?
Yes, sir.
Are you pleading true to that voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true nonetheless?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. What are we doing?
When you're here, we recommend.
Okay,
I brought you.
that's okay.
I put
These kind of-
sure as well.
As the day goes.
He can be taught.
I'm amenable to line. Behavior modification.
Yeah, I've seen your report card. It says needs work.
That needs improvement. And I've got a lot.
An agreement's been reached where your probation would be revoked. You would be found guilty of this underlying state jail felony and sentenced to 1 year in the state jail. And you would be given credit for all time you have served in connection with this. Is that your understanding of the claim?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
She probably has around 280 days. She'd be back to the.
You're paid by legal supposedly. I wish I had a bigger pay now. There's a pay.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the
Yes, sir.
contents true and correct? State's Exhibit 1 tendered in test without objection admitted. This states, among other things, that you are waiving all rights of appeal. If I follow this agreement, I am going to do that.
Yes.
Anything further to add?
We rest.
If not, I'm going to find that you are pleading true to allegation 1 of this first amended motion to revoke unadjudicated probation voluntarily, known, intelligently. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. It is so revoked, and your deferred or unadjudicated probation is hereby revoked. Earlier in this case, on or about June 18th of last year, in this court, you pleaded guilty to this attempted harassment of a public servant, a state jail felony, voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty.
Yes.
There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that hearing to find you guilty beyond a reasonable doubt. Now, I find you guilty based upon the revocation of your probation. I find you guilty beyond a reasonable doubt of the state jail felony, and you were hereby found guilty beyond a reasonable doubt and sentenced to confinement in the state jail for 1 year. Do you understand what has happened today?
Yes, sir.
Do better. You can.
Just what?
You can. All, that is all. Thank you.
That's all I have, Your Honor.
Guess what?
In this court proceeding, a woman appeared before the court for a hearing on a first amended motion to revoke unadjudicated probation. She had previously pleaded guilty to the felony offense of attempted harassment of a public servant and was placed on 5 years of deferred probation. Prosecutors alleged that she violated several conditions of her probation, including repeatedly failing to report to her probation officer, failing to provide proof of community service hours, not completing a required anger management program, and failing to pay court-ordered fees. During the hearing, the prosecution abandoned a separate allegation related to a new charge of failing to identify. The defendant waived the formal reading of the motion and pleaded true to the allegation that she failed to report as required. The judge explained that admitting to even one probation violation gave the court the authority to revoke probation, formally adjudicate guilt on the original felony charge, and impose a state jail sentence ranging from 180 days to 2 years. After confirming that she understood the consequences, the court moved forward with a negotiated plea agreement between the defense and the prosecution. Under the agreement, the defendant's deferred probation was revoked, her guilt was officially adjudicated, and she was sentenced to 1 year in state jail. The court also awarded credit for the significant amount of time she had already served while awaiting the hearing. Finding that her plea was entered knowingly and voluntarily, the judge accepted the agreement, entered a conviction for the underlying felony offense, and imposed the agreed sentence. As part of the plea arrangement, the defendant also waived her right to appeal, bringing the case to a final conclusion.